Good morning, everyone, and welcome. We're pleased to have you with us today. We have 4 cases on the morning docket, and we will call them in the order in which they appear. We will take a very brief break after the first case to make a change in the panel. But other than that, it'll be smooth sailing. Each side has a total of 15 minutes. That applies whether there's one or multiple lawyers arguing. So if there's more than one of you, you'll need to share that 15 minutes. The appellants may reserve up to 5 of their 15 minutes. So after you've introduced yourself, please tell us how many minutes you wish to reserve, and the clock will be programmed accordingly. Are there any announcements or introductions? Hearing none, please call the first case.
Robert W. Hallman versus Austin Peay State University.
Good morning, Your Honor. May it please the court, I'm Joe Wyant for the
morning.
appellant. I would like to reserve the full 5 minutes, please,
5
for rebuttal.
minutes.
Thank you. Your Honor, I am here today on behalf of the appellant, Mr. Robert Hallman, who is now 81 years old. The subject time at issue, he was 76 years old when he applied for title of full professorship at Austin Peay State University up in Clarksville. He was, of course, denied that, and we are, of course, here challenging the grant of summary judgment dated August 24th, 2023 by the Chancery Court of Montgomery County. I have no intention of belaboring the issue today. It is certainly our position that Dr. Hallman met the requirements to be named a full professor. Publication requirements, chiefly. And those are, of course, written. Those are policies that are written and that are put out by the university. And everybody sees them that works there. Dr. Hallman had started at Austin Peay back in 1987. He was named associate professor in 2001. He had been tenured back around 1993. And he has published around 10 articles. What seemed to have taken place here, though, in the analysis of Dr. Hallman's application is that the provost took a subjective attitude toward his papers instead of an objective attitude. He had appealed that decision by the provost not to name him a full professor. And in fact, the appeals committee said that he met them, met the actual requirements, which he had to publish 2 articles in the last, I believe, 2 years. But of course, even the appeals committee made a little comment. We feel that he's met the requirements, but we don't like what he wrote, basically, is what they said.
It addressed the quality, I think they
Yes.
said, of the publications.
Yes, Your Honor, which, as I have briefed, is not allowed. University policy overriding that actual departmental policy.
Counsel, isn't that more of a contract issue than a discrimination issue, though? I mean, if the contract defines how you assess quality and says it's just objective, it's numerical, can't you have, I mean, let's say the university went awry here and they violated the terms of the contract. That doesn't mean they discriminated, though, does it? And on the basis of age. I mean, maybe your contract claim is valid on that point, but does that really show discrimination with regard to age?
Well, the reason that we brought up the THRA claims in the first place is because we have a case here where Dr. Hallman met the actual written policy requirements. And the fact that he was 76 comes into play. But we couldn't see that there was any reason why he should have been turned down. So I took the view that the reasons given were actual pretext.
Is there any evidence in this case as to the quality of the scholarship produced by the comparators that you offered? I know you offered younger comparators, essentially saying there were younger faculty members who did receive tenure. Is there any evidence in the record addressing the quality of their work, showing that that their scholarship was of the same or similar quality as Dr. Hallman's?
Not in any substantial way. It's not in the record. But I wholeheartedly agree with you that it is a breach of contract, his employment contract with Austin Peay when he started way back when. They did not stick to the actual written policy that Dr. Hallman planned for and tried to perform. And I mean, he does exactly what the written policy says, and then he is turned down for full professorship.
But did the contract provide for promotion?
Well, my understanding is that it did, Your Honor, that it talked about how you get ahead, how you would rise at the university.
But was there a right to promotion based upon the contract?
I don't know that I would call it a right, but there was an expectation, as in any contract, the duty of good faith and fair dealing, that both parties have to honor what is in the contract. And Dr. Hallman did, and then we found ourselves being refused. The university didn't perform. So that is how we got to the THRA claims.
Counsel, you wouldn't disagree that quality is part of under the terms of the contract, the quality is part of the assessment in terms of whether somebody becomes a full professor or stays as an associate professor. In terms of, I'm assuming you wouldn't disagree with that. Your disagreement is in terms of how you assess quality, right? Or do you object to the entire, can Austin Peay not assess quality at all?
My understanding in reading all the policy documents of Austin Peay is that quality doesn't come into it. Quality is taken care of, is actually measured by these outside entities that choose to either publish or not publish a paper. And Dr. Hallman, you'll see in the brief, had even won Best Paper Award on one of these. And quality, it's not for the university to second or to take a second look at it and scrutinize it with its own eyes when the entity that published the paper has already done that task for Austin Peay. And Dr. Hallman did exactly what the policy statements told him to do. What they tell anybody who wants to be a full professor to do.
If we may, Mr. Wyatt, on the discrimination claim, I would like to talk about the university's claim that they had a legitimate non-retaliatory reason for their decision, and that the trial court seemed to make a very firm finding that there was a lack of adequate proof of pretext on the part of the university. How do you address that?
Well, we probably could have shown a lot more, but the pretext argument, again, just goes back to we did what the policy documents say for a person who wants to be a professor, what the person has to do. That was accomplished, and we were turned down. And one has to think about other reasons. When the policy said that it should have happened, one goes to the idea that, well, there must be something else. And so what they've told us, since it didn't make sense, since it didn't reflect what the policy of Austin Peay is, that there must be some other reason. And we labeled it pretextual.
That's speculation. I mean, what evidence do you have that there was a reason?
Well, that's all that we ever have in pretext. You can never fully prove it.
Well,
but
you can, but there are times when you can.
Well, there are times. Excuse me.
But you couldn't this time.
Not wholly, but I mean, that is the reason. We're just assuming, which is what you do in pretext. You have to say, well, this one doesn't make sense, and of course that's for the judiciary, for the judges to look at. But it doesn't. The policy is not being enforced, and the question became why. And so we have a 76-year-old man who has tried in the past. This was the second time to be a full professor, and there were two close in time EEOC complaints. In fact, within a 24-month period, and then he has been denied, and he's 76 years old at the time, and he met the written policy requirements for Austin Peay to be a full professor.
He had been denied the first time before he filed his first EEOC complaint. The first EEOC complaint came after the first denial. Is that correct?
I believe so, yes. Nevertheless, and I have briefed this, but I'll say, to interject personal subjective criteria that differs from what is stated in the policy is a violation of the policy and the actual employment contract, as Your Honor mentioned. Objectivity is the requirement of the policy. Professional judgment that is inconsistent with objective standards is not objective and is a violation of that stated policy. Provost Gandy said it in his deposition, and I mean, he just said this, it's not written down anywhere, that it's both a subjective and an objective standard. And that's just not what it says in the written policy. Dr. Hallman did what the contract would have him do if he wanted to be a full professor. And Austin Peay didn't perform its corresponding duty to act in good faith and fair dealing under the contract. Thank you.
All right, thank you, Mr. Wyatt. We'll hear from you on rebuttal.
Thank you.
Good morning.
Good morning, Your Honors. May it please the Court, my name is Jeffrey Cadle with the Office of the Tennessee Attorney General, and I'm here representing the defendant, Austin Peay State University, in this matter. Now, in the lower hearing, after defendant filed this motion for summary judgment, the trial court reviewed plaintiff's evidence and determined that plaintiff did not put up sufficient evidence to support his claims of age discrimination and retaliation. The trial court was correct, and the court should affirm the dismissal of plaintiff's claims. Plaintiff applied for promotion to professor 5 years in a row, from 2014 to 2018, and he was denied for promotion each time. For the most recent promotion application, which is the only one at issue in this appeal, the president of APSU denied plaintiff's application because, one, his research was not relevant to his experience or work, and two, his research lacked proper methodology. These issues were not unique to the most recent denial. In fact, plaintiff's publication record was at issue in all 5 of his promotion applications. So this is a consistent line throughout everything.
Did they offer the same reasons every time?
Yes, Your Honor.
Okay.
It was always dealing with the quality of his work. And I believe that Dr. Hallman actually submitted a lot of the same work, again, for the following applications. Now, in this case, plaintiff provided no direct evidence of discrimination or retaliation, and therefore, in this situation, Tennessee courts followed the McDonnell-Douglas framework to evaluate the sufficiency of the evidence. As the court noted previously, the trial court in this case focused mainly on pretext. Now, when it comes to retaliation, there's also an issue of the prima facie case, which the trial court found that the plaintiff did not meet the prima facie standard for discrimination, and Dr. Hallman has not appealed that claim. He has not addressed it in his brief, so we believe that that particular issue is waived. But even so, as the trial court found, there is no evidence of pretext in this. The reason that the university gave was lack of quality of the publications, and Dr. Hallman was not able to come up with any evidence whatsoever that the university did not believe that. In fact, Dr. Hallman admitted as part of the summary judgment motion that the decision to deny his application made by the president, Dr. White, was based solely on her academic judgment.
Counsel, under the university's promotion policies, how do you assess the quality of work? Opposing counsel says it's subjective. You look at the numbers. If you're accepted for publication and published in a refereed journal, that's an assessment of quality. What's your understanding of the policies of Austin Peay University in terms of how you're supposed to assess quality?
Well, quality is always going to be somewhat of a subjective as well as an objective review. The Austin Peay University's policies repeatedly talk about sustained quality and academic excellence. There's also a statement in there that gaining full professorship is not a right, but something that is earned with specific criteria. And one of those criteria is quality of your scholarly work.
Is there any definition or any sort of structure provided for how quality is going to be assessed, or is it just left at you have to produce quality scholarship?
There's no specific standard in the policy, and I believe that it is that way intentionally because the university has a whole lot of different disciplines, and determining what is quality for one particular discipline is going to change for another discipline. So there is a whole process built up from the college level all the way up through the president. Each one assesses the quality at their level and makes a determination. And whenever it gets to the president reviews all the information below them, and they also make their own finding as to whether they believe that the work is sufficient quality. And in this case, council even admitted that the appeals board that was a step right before the president, even though they agree that he technically met the number of publications, they still had problems with the quality of his work. And so whenever the president took all of those opinions into consideration, in the president's opinion, and that's really the final decision maker in this case, the president believed that Dr. Hallman did not meet the adequate quality standard that the university was trying to put forward with its professors.
General, aside from the other issues, does the trial court's finding of a lack of evidence to suggest that the university's decision was pretextual, is that dispositive of this case?
Yes, it is, Your Honor. In fact, that's part of the THRA, is that there has to be some showing of a pretext finding. The McDonnell Douglas was actually codified into law. And so without that factor, the plaintiff has no case. And really, in order to prove pretext, you can't rely on suspicions. Plaintiff has to actually provide actual evidence. It can be circumstantial evidence, but it has to be something. And in this case, the plaintiff did not provide anything. And as for the breach of contract claim, sovereign immunity clearly applies. The General Assembly has passed a statute that would allow for the waiver of sovereign immunity, but only for claims brought before the Claims Commission. Breach of contract is a claim that must be brought before the Claims Commission. It cannot be brought before the Chancery Court absent a special procedure where the Claims Court originally gets it and transfers the case to the Chancery Court. That did not happen in this case. Therefore, sovereign immunity applies, and plaintiff is not able to pursue his claim for breach of contract. Are there any further questions, sir?
Hearing none, thank you, General.
Thank you for your time.
All right, Mr. Wyatt, your rebuttal.
Thank you, Your Honor. I would add that appeals committee at the university level that said that Dr. Hallman met the requirements, though they didn't really like the quality or maybe didn't like what they had read, they actually passed him on and said that he should actually get the promotion. Turning from the THRA claims, which seem to be weakening every minute as I'm hearing this, and I say that tongue-in-cheek, but Justice Usman had asked about the breach of contract. Now, that is how I had first framed this lawsuit. And early on, Chancellor McMillan dismissed that one and said that we couldn't bring that in the Chancery Court. But I have, of course, briefed the issue. I see the Familoni and the Robertson cases indicate that I can bring that in Chancery Court with the THRA claim. It doesn't say the THRA claim has to prevail, but it got me into Chancery Court. And Your Honor, that's exactly what this is, chiefly, as a breach of contract, a breach of employment contract. I would just point out a little language. It's on page 31 of my brief, and it is quoting a note on page 8 of the APSU tenure procedures and guidelines, which says the notice of tenure track appointment and agreement of employment is a legal document that, along with applicable university policies, governs the faculty member's employment and relationship with the university. The second part of that was interpretations of a faculty member's contract that contravene or deviate from what is explicitly stated, such as years toward tenure, requirements for the promotion, and conditions governing employment are not permitted.
Counsel, what would you point the court towards to show that the assessment of quality is supposed to be numerical and essentially outsourced to the determination made by the referee journals? And what provision in the policies would you say that's what shows that you've been accepted in a referee journal, the journal has said you meet our quality standards? Where in the policies is that supported?
Well, the university policy has left it to the departmental, to the departments to make specific requirements for the number of publications, and in this case, it was 2. Dr. Hallman has had 10. As I said, he even won Best Paper Award for at least one of those papers. If this is not a THRA claim, it is definitely a breach of contract claim, and this could be the case where the court revisits Familoni and Robertson. Thank you.
All right. Thank you, Mr. Wyatt and General Cadle, for your arguments. We will take this matter under advisement. We're going to take a very brief break, so don't go anywhere.